Thank you so much, Ms. Wells. It is in fact 1 p.m. and I will call this meeting of the Senate Judiciary Committee to order on Thursday, February 18th. I would ask our esteemed secretary to please take the roll.
Vice Chair Cannizzaro.
She is held up in another meeting. I would ask that you please mark her present when she arrives. And as always, I will try to make a record of it as well.
Senator Orenshaw.
Present.
Senator Harris.
I believe Senator Harris is on her way, and so I would ask that you mark her present when she arrives, and I will try to make a record of it as well.
Thank you. Senator Settlemeyer.
At the Dayton Courthouse.
Senator Hansen.
Here.
Senator Pickard.
Here.
Chair Scheibel.
Here. And our first order of business today is hearing SB 107. I would like to note for the members of the committee, as well as anybody else who might be joining us, that a conceptual amendment was submitted shortly before the hearing. It's my understanding that most of the stakeholders involved were working on that amendment. It's certainly not my intention to blindside you with late additions to the calendar. So before we dive in, I do want to ensure that every single member of the committee received my email with the amendment and has no trouble opening it. It's not very long. Did everybody get it? I'm seeing nodding heads. Anybody not? And I also see Senator Harris and Senator Cannizzaro are both present. If the secretary please mark them present. Were you both able to access the amendment? All right. And for those of you following along at home, the amendment is available on Nellis. It is an exhibit you can access it either through the February 18th meeting or through SB 107. Again, it's not terribly lengthy, so I trust that you will have time to review it during the presentation, and you can talk about it in your testimony if you need to, which brings me to my next reminder. We will be having testimony after the presentation of the bill. We'll start in support, opposition, and then neutral testimony. I'm keeping track of the people in the queue the best that I can. We'll start with 20 minutes in each position, and I may have to adjust up or down if these numbers change drastically. Other than that, please also remember that you don't have to repeat anything that anybody else has said. You can always just say, my organization feels the same way, or also in the same position, or ditto to what the previous caller said. And as always, you can submit your testimony in writing to sen@sen.state.nv.us, and all of your written testimony will also be added to the record. And with those quick reminders, we are now ready to open up the hearing on SB 107. And I believe that Senator Orenshaw will be presenting this bill.
Yes, thank you, Chair Scheibel. Thank you, members of the Senate Judiciary Committee, for hearing Senate Bill 107 today. For the record, my name is James Orenshaw. I represent State Senate District 21. That's parts of Henderson and unincorporated Clark County. Senate Bill 107, certainly I'm sure many members have received quite a few emails about this bill, and I want to assure the committee that, well, first of all, I'd like to thank all the stakeholders who've worked on the amendment. The amendment is up on Nellis, and I'd like to ask the committee members to look at the amendment on Nellis, which would replace the original language in the bill. I believe that if enacted, this would actually bring more clarity to the law and lead to less litigation and less lawsuits perhaps having to be filed. With me today, Chair, I have JP Kemp from Las Vegas, Nevada, who's an attorney who primarily practices in this area. He also was the attorney that litigated the Patouche case up to the Nevada Supreme Court. Chair, with your indulgence, I'd like to turn it over to Mr. Kemp.
Please go ahead, Mr. Kemp.
Thank you. Good afternoon, Chair, members of the committee. For the record, I'm JP Kemp. I'm with the Nevada Justice Association, and we are in support of SB 107, and we'd like to thank Senator Orenshaw for inviting me to speak about SB 107 today. This bill deals with two related issues related to limitations of actions, or also called statutes of limitations. The first one, and the main one we were first looking at in this, is the catch-all statute of limitations, which is 4 years under NRS 11.220. And also, there's a provision in Section 1 of the bill to establish a statute of limitations for cases of wrongful termination. And really, we're talking about common law wrongful termination of employment cases. It'd be helpful for me to give a little bit of background on employment law in Nevada. I'll do it very briefly. Generally, employment in Nevada, unless you have a contract for a specific period of time or a contract that says you can only be terminated for cause and identifying those causes, your employment is at will. And at will means that either party to the employment relationship can end that relationship at any time for any reason or for no reason at all. You can walk into work one day and your employer can say, I don't like the color of your shoelaces. You're done, bye-bye. And it can be that arbitrary and that harsh on occasion. But that is the general rule that underlies all employment in Nevada, is that it is at will. There have been exceptions to the at-will employment doctrine that have been developed over the years to ameliorate some of the harshness that can result from having that total arbitrary ability to terminate someone without any sort of recourse. And the exceptions are both statutory and through the common law. Sometimes both apply, depending on the situation. And that's why when we talk about the Conceptual Amendment to Section 1, that'll become more clear as we go along. The common law exceptions, the Supreme Court of Nevada has recognized that there are some matters of public policy that the at-will doctrine has to give way to. It calls them rare and narrow exceptions, but there are exceptions based on compelling public policy. The first one that was recognized in Nevada was in 1984 in the case of Hansen versus Harris. And that is where an employer retaliates against an employee for filing a workers' compensation claim or pursuing their rights to workers' compensation under the Nevada Industrial Insurance Act. Another one, whistleblower retaliation, recognized by Wiltsey versus Baby Grand and some other cases. That's essentially where an employee complains to a government agency that has regulatory oversight about something that the employer is doing that is illegal. When an employee blows the whistle on the employer and the employer turns around and says, oh, you squealed on us, you're fired. An employee does have a common law cause of action for retaliatory discharge, wrongful termination for that situation. And another one that's been recognized is a refusal to do something unsafe or illegal. The courts basically said you don't have to put yourself in severe jeopardy or turn to a life of crime in order to earn a livelihood. One of the big cases on this was D'Angelo versus Gardner in 1991. The companion case, Western State Minerals versus Jones. Mr. Jones worked at a mine, and the employer was insisting that they work with cyanide when they had an open cut. They had an open cut on their body, and so working with cyanide would have been dangerous. And when they refused to work with the cyanide, they got fired. And the court said, yeah, that's a compelling reason, and we're going to find an exception to the at-will doctrine there as well. Statutory exceptions, primarily it's illegal discrimination. The at-will doctrine will be set aside for issues of illegal discrimination on the basis of age, race, religion, color, national origin, disability, sex, and in Nevada, sexual orientation and transgender status also are specifically recognized as protected classifications. Also, retaliation for engaging in protected activities. If you go to the boss and say, hey, I'm being discriminated or harassed by my coworkers because of my sex, for example, and the employer says, well, we like those coworkers better than you, so you're fired. That type of a retaliation when you've engaged in protected activity will also give rise to a claim that would be an exception to the at-will doctrine. We also have great new protections in Chapter 613 for pregnancy, specifically. And there are other statutes out there too. If you're fired for not getting yourself out of jury duty, there's a claim. If you're fired for testifying truthfully as a witness in court or an administrative proceeding, there's a claim for that. It's under Chapter 50 for witnesses. If you get fired for not doing business with particular people or businesses that your employer wants you to do business with, there's a claim for that. And there are a number of others throughout the statutes. But again, the principal one that we looked at and that we're considering today are the discrimination cases, which require administrative exhaustion. If you get sexually harassed or you get discriminated, fired for race or for sexual orientation, you can't just run off and file a lawsuit. Before you can do that, you have to file a charge with the state or federal government agencies that have oversight over these statutes. The state agency is the Nevada Equal Rights Commission. The federal government agency is the Equal Employment Opportunity Commission. And this is sort of where the amendment that we're looking at to Section 1 of SB 107 comes into play, because the process for filing a charge, and you can file with either one, the Nevada Equal Rights Commission or the EEOC, they have a work sharing agreement because they both enforce anti-discrimination laws. And so they got together a long time ago and said, right, we should like kind of combine forces here. And so they do have a work sharing agreement where if you file with one, they will automatically file with the other agency for you. So if someone goes and files with the Nevada Equal Rights Commission and it's deemed that they've automatically filed with the EEOC, and the charge filing process, I'll go through NERCs because it's the Nevada Equal Rights Commission's kind of, that's the one I'll choose to go through. They have an intake portal on their website where you can go and fill out an intake questionnaire on who the employer is, who you are, who would be the witnesses, what exactly happened, what's your complaint all about. You submit that intake questionnaire, and then the Equal Rights Commission will set up an interview. Now, the time limit to go and file a charge with the Nevada Equal Rights Commission is 300 days. You have 300 days from the date that you get discriminated against to bring that charge. And generally, it's, when you submit the intake questionnaire, that's sort of deemed as you intend to file a charge, and so they usually use that date. The problem starts to arise with, it takes 4 to 5 months from the time that you submit the intake questionnaire to get your interview, an intake interview with the Equal Rights Commission. And that's just a function of how busy they are. They get a lot of cases and they have limited staff. It takes a while for them to process people through. So 4 to 5 months later, you get that interview. At that interview, they will generally type up the charge, or shortly thereafter, they'll type up the charge and get you to sign it. And that's a formal charge of discrimination. They then go into an informal settlement meeting. And it generally takes 60 to 90 days to complete that informal settlement meeting. If the informal settlement meeting settles the case, then great, it's done, it's finished and over with. But usually it doesn't, and usually it will then go into investigations, and it can sit there for many months waiting for an investigator to be assigned and then they look at it, they ask for information from the parties, and they make a decision whether they find probable cause or don't find probable cause. If they don't find probable cause, they issue a closure letter, and they give you a letter that says you have 90 days to file a lawsuit from that point. If they do find probable cause, then they enter into conciliation where they get the employer and the employee together, and the NERC basically takes off its investigator's hat and puts on its advocate's hat and says to the employer, look, we found that there's probable cause that something was wrong here. And so you might want to settle this case. And so they do this formal dispute resolution process called conciliation. And again, either it gets resolved or if it doesn't. And if it doesn't, then generally there can be administrative hearings, but in most cases they issue a final decision. We found probable cause conciliation has failed, you have 90 days to go file a lawsuit now. And so the statute of limitations for a wrongful termination case that we're talking about here, it creates a conflict. It creates a problem and a tension between these two processes, because your common law wrongful termination case that there is no administrative process for, you have to bring it to court, and you have to bring it to court in time. The Equal Rights Commission process can sometimes take 3 or 4 years, and paradoxically, the stronger the case is, the more likely that there is discrimination that's going on, the longer the process with the Equal Rights Commission takes. So it can take 3 or 4 years to get through the administrative exhaustion process. Meanwhile, the Supreme Court of Nevada, in a case I had called Patush versus Las Vegas Bistro. Las Vegas Bistro is the name for the corporate name for Larry Flint's Hustler Club. Ms. Patush was an office manager there who tripped and fell, and her workers' comp claim took about 3 years to work its way through with all of the treatment that she had. She came to me and wanted to file a lawsuit. Well, the federal courts had looked at this and they decided that there was a 2-year statute of limitations, even though there's no statute of limitations listed in Chapter 11 of NRS for that claim. And so the federal courts had been following that, and a lot of these cases do end up in federal court because the federal claims that are brought under Title VII or the Americans with Disabilities Act or Age Discrimination Employment Act, when you bring those cases along with your state cases, then the employer has the ability under the federal question rule to remove the whole case to federal court. And so that's why the federal court had mostly ruled on this. The Supreme Court of Nevada had never addressed the issue of what the statute of limitations is for this wrongful termination claim. And looking at it, NRS 11.220 is the catch-all. And it says, if there's no other statute of limitations listed in here, use 4 years. And so I said, well, there's no other statute of limitations listed, so I guess it should be 4 years. And so we went and we argued that with the Supreme Court, and they said, well, we see your point, but no, we're going to go with the 2 years. Now, it's interesting, the 2-year statute of limitations comes from the personal injury and wrongful death statute. And it says, and I'll quote it here, an action to recover damages for injuries to a person for the death, for injuries to a person or for the death of a person caused by the wrongful act or neglect of another is a 2-year statute of limitations. And I looked at that and I scratched my head and I said, no reasonable Nevada citizen is going to read that statute and come to the conclusion that if they got fired from their job for an illegal reason, that they only have 2 years. So again, the Supreme Court looked at it and said, well, it's injuries to personal interests, and so we're going to go with the 2 years. The problem is this: if it's taking 3 or 4 years to go through the Equal Rights Commission process, and you have both claims, you have both a retaliatory discharge common law claim that you can bring, and you have a statutory discrimination claim that you can bring, you're going to have to go to court long before Equal Rights Commission has finished with their process. And so lawsuits have to get filed and money has to start getting spent before we've ever gotten to the part where we see if we can do conciliation and reach a settlement of the matter while it's still in the administrative process. Because there was no prior specific statute of limitations, the catch-all would have been 4 years. We thought, well, 4 years would be a good period of time to give time for this to work its way through the system. And that's why the Section 1 of SB 107 is written the way that it is, and it's put under the subsection 2 of NRS 11.190, which is a 4-year statute of limitations. Well, we got some pushback and some people are concerned about that. And so we wanted to see if we could come to a way that addresses the problem and the tension that we were aiming at, while still sticking with this 2-year limitations period. And so the conceptual amendment, it will essentially say, okay, for the common law retaliatory or wrongful discharge type of claim, it will be a 2-year statute of limitations. However, that 2-year statute of limitations doesn't start to run until, so it's told, and it doesn't start to run until the pending related state or federal administrative agency charges or complaints have been exhausted, or if there's a related industrial insurance claim for workers' compensation, that has been closed. And that one's important. The workers' comp, I'd just like to point out, workers' compensation, when it gets to the end of a claim, they have to determine whether or not the employer is going, if the person can't go back to the job they were doing originally, are we going to have the employer put the person to work in a different job? And that avoids the expense of vocational rehabilitation and retraining the person to do something else. So at that point, even if the employer had previously terminated the employee, they could look at it and say, well, why don't we could probably use this person. We've got a job that we could put them in, and they wouldn't have to go through the vocational rehabilitation process. Again, if an employer goes ahead and puts somebody back to work after they've finished their claim, there wouldn't be any reason to file a lawsuit at that point because the person would continue to work for the employer, even though there had been a gap in time, but they had been receiving workers' compensation benefits in the meantime. And so that's kind of where our conceptual amendment to Section 1 of SB 107 is coming in. It's to basically provide for the time for administrative processes to work their way through so that people don't have to rush out to court to meet this 2-year time limit. But at the same time, keep the 2-year limitations period that some of the interested parties that are in opposition would like to see maintained. So that is the conceptual amendment to SB 107. The other part, we would still like to make clear NRS 11.220, which is the catch-all. We'd like to see that made clear that if there is no other statute of limitations listed somewhere, use the 4-year limitations period. There have been a couple of, the Supreme Court of Nevada, I mean, and the way that these things are done in a number of other jurisdictions are that when there is no specific statute of limitations, the court will look for an analogous statute of limitations to apply. And so, for example, there have been one case that comes to mind is intentional interference with prospective business advantage, or it's sometimes called intentional interference with prospective economic advantage. There's no statute of limitations listed for that one, but the court has analogized it to being, well, in one case they analogized it to being like fraud and applied a 3-year statute of limitations. And in another one, they analogized it to, because it interferes with contract, that it's somehow like an unwritten contract, which is 4 years. So they've actually got a little bit of a conflict there. But again, it would be much better and people would have much more stability if they could rely on the fact that the court was not going to try and guess a different time period and just use what the legislature has indicated. That the legislature in NRS 11.220 has said, hey, if there's no other time limit listed, use the 4 years. And if you can stick with that, it really lends predictability to the process. And I think it would be a very good improvement in this area of the law. I think that I love to hear myself talk, but I think I've gone on long enough. Madam Chair, if there's any questions or anything that I can help try to clarify or explain, I'd sure be happy to do that.
All right, thank you so much for your presentation. I think we do have a couple of questions from members of the committee. I will start with Senator Pickard.
And thank you, Chair Scheibel, and thank you, Mr. Kemp and Senator Orenshaw for presenting the bill. Honestly, I had trouble reconciling the 4-year and the 2-year the way it was originally written. I do really like the amendment. And I agree with your analysis as to the catch-all. It's not a catch-all if we then have to still go back and consider, what's analogous. I do like that. The only question I have is particularly after you've exhausted, and I recognize some of it, NERC and EEOC claims take more than 4 years. So without this, we actually lose the ability in some cases to go after a judicial review if the administrative efforts are exhausted and don't come up the way that the applicant may want. But in any event, I still tend to agree with the Supreme Court's reasoning that this is a type of injury. It's a financial injury and maybe a reputational one, but it's still analogous to that 2-year. I wonder why 4 years instead of 2, particularly if you've already developed the case in the administrative action.
Right. Senator Pickard, through the chair to you, and for the record, JP Kemp, Nevada Justice Association. The reason that we had gone with the 4 years is because of the length of time that it can take. That's what we had in the original bill. We said, well, sometimes these kids. I mean, I have one that I filed recently, where it was just over 3 years that it was with the Nevada Equal Rights Commission. The Nevada Equal Rights Commission did find probable cause. We went through the conciliation process. We're not able to find a resolution, and so we did have to go to litigation. So yeah, that gentleman was terminated in 2017. It does take that period of time. We thought 4 years would be, in the run of things, a lengthy enough period of time to get everything accomplished before we would have to turn to litigation. The amendment would work just as well, because basically we don't have to worry about rushing off to court and not having the opportunity to go through the administrative resolution processes. I think it accommodates both concerns, because there are some of the two, like whistleblowing, for example. There are some OSHA whistleblower complaints that can be made administratively, but a lot of those will not have administrative claims filed. Again, if employer requires somebody to do something illegal or unsafe, a lot of those would not have administrative processes to go through either. And so the 2-year statute of limitations makes sense there. Again, I know that some people in opposition to this point out, well, somebody knows that they've been done wrong and should be able to do this within 2 years, and that's a fair criticism. And in most cases, that's true. There are a lot of cases, though, where people don't actually learn about that their rights have been violated, or that something's been done illegally to them until much later. Maybe they run into a former coworker in a grocery store and say, yeah, they fired you because you wouldn't steal for them, or something like that. So they may not learn about it until later. The 2-year statute of limitations is generally sufficient in a number of cases, it's true, but the lengthier period of time for the administrative process is kind of what we're looking at here.
All
I
right.
hope I've answered your concern.
Yes, and so with the amendment, though, we're back to the 2 years after we've told the case for the exhaustion of the administrative remedies. Is that correct?
Yes, that's
Okay.
correct.
All right, I'm satisfied. Thank you very much. Thank you, Madam Chair.
You're welcome.
All right. The next hand that I saw was Senator Settlemyer, so I will go to you next.
Thank you, Chair. I appreciate that. My question was similar to my predecessor. I appreciate the amendment. It takes care of a lot of the concerns I had. Still a little worried that, these actions, I'm told by a friend of ours that it takes 300 days. Usually you have to file them within 300 days of termination, and then this would toll it during that time frame. So that potentially adds 4 years. I do get concerned that sometimes I'm told it takes a little while to find witnesses. So I'm still concerned about that. I'll just keep sitting on that. But I'm more concerned. I'm getting some messages from local government saying that this also then, am I correct in saying this will extend Section 1983 civil rights cases?
Well, so Section 1983 is a statutory claim, and that's why we specifically mentioned that these are for tort claims for common law wrongful termination. So Section 1983 is a federal statute. So by definition, it would not apply here.
Okay, then I can tell my local government folks they're wrong, and this doesn't apply to them. They can leave me alone. So I appreciate that information very much. Thank you, and thank you, Chair.
All right, and we will move next to Senator Hansen.
Thanks, Chair Scheibel. Couple of questions. So you have a federal process that you go through, and that has up to 4 years, if I'm understanding correctly, possibly before you can reach a possible resolution. You go through the 4-year federal process, you're unsuccessful, then you want to come back and have another bite at the apple on a different level, right? On one hand, you're maybe a discrimination case, but now you want to come and start the whole process over for the employer on the basis of an unlawful termination. So in effect, if my numbers are right, am I pushing? You could theoretically string this out for 6 years or more.
Madam Chair, through you to Senator Hansen, for the record, J.P. Kemper, Nevada Justice Association. Senator, in very extreme cases, that could happen, but I'll tell you in most of the cases, you are going to have it happen sooner than that. In terms of the employer being concerned about, well, witnesses and evidence disappearing, generally they would be collecting that through the administrative process anyway. In order to address a charge with the Equal Rights Commission, they have to file, in the EEOC, they call it a position statement. I'm not sure if they use that same nomenclature for the state process, but they essentially have to respond to the charge generally within about 60 days after the charge, after they receive the charge. They've got to answer it. So they'll be on notice that they need to preserve evidence. They need to figure out who the witnesses are and figure out which documents would apply. They would do that in the administrative process. Again, most of these cases, somebody got fired. So it's basically the same, the fancy legal term is common nucleus of operative fact, right? And so the employer will have had notice of that and will know what's going on with that from a fairly early stage, even though the administrative process could go out for a period of time, and somebody would have time after that to file their claim.
Okay, well, if you have the common nucleus concept, that would apply to your client in that case as well, would it not? I mean, in effect, what we're doing here, from what I can tell, is you have an opportunity first to drag an employer potentially through a several-year process, and then you don't want that to be tolling on the current statute of limitations. You then want to be able to, even if you said you did not find a resolution, in other words, your client lost, you then want to be able to turn around and have at least another, maybe a 4-year window to then essentially drag the employer through another whole process of possibly unlawful termination rather than what the original case was. But I don't know, it just seems to me the whole concept of speedy trials, getting things resolved in a reasonable window of time is probably why the Supreme Court had the 2-year window. And that common nucleus concept obviously would apply just as much to you. And as an attorney, if you have several possibly conflicting ways to sue an employer, then you as an attorney would pick the most reasonable one with the strongest case to move forward. And if in fact, after you've done that, you fail in a federal procedure, to then turn around and say, well, now we're going to start the tolling process on the Nevada law side of it, and you could carry that thing out for years and years and years, just seems extremely unreasonable to me. So anyway, Madam Chair, I have some real concerns on this bill on a variety of points, as you can tell. But the biggest one is, I think there are good reasons to have statute of limitations. 2 years seems reasonable to me. So thank you, Madam Chair. Thank you, Mr. Kemp.
All right.
If I could briefly reply to my colleague Sparks, thank you. Through you, Chair, to Senator Hansen. As I've studied the issue with the current decision from the Nevada Supreme Court setting that statute of limitations at 2 years, many workers in this situation may rush to file an action that, if the administrative remedies were to work their way through that process, whether state or federal, could be resolved, and this lawsuit would never be filed. So I understand your concerns, Senator Harris, but to the contrary, I believe that with the compromise amendment, if that becomes law, actually there will be less litigation. Thank you, Senator Hansen. Thank you, Chair.
All right, it looks like there is one more hand. We have time, so I will give Senator Settlemyer a second bite at this apple. Go ahead.
Thank you, Chair. I appreciate that. And I never thought of this particular bill as something dealing with workers' comp. So when Mr. Kemp said it, it kind of caught me off guard. How does this affect, I mean, it was a long time ago, way back when, the concept of workman's comp was supposed to be, some people call it the grand remedy. That is the remedy. So you mentioned that in relation to this. So how will this affect workers' comp claims?
So the grand bargain of workers' comp, where employees give up their right to sue for personal injuries, and in return they receive the set benefits under the statutes and the workers' compensation laws. This is so the first case that recognized exception to that will doctrine was Hansen versus Harris, as I mentioned, in 1984, and essentially it's outside of the workers' compensation process, because the physical personal injuries, I guess it could also be, if you're a 7-Eleven clerk that gets held up at gunpoint and you have PTSD, I mean, it could be those types of mental injuries as well. Those get handled through the workers' compensation process. You get treatment and you get benefits for that. But it's where the employer says, you know what, you filed a claim against us, that's going to cost us money, and we don't like that, so you're fired. What that does is that has a chilling effect on other employees filing workers' compensation claims. And so the Supreme Court in 1984 in Hansen versus Harris said, world can't work that way. People have a right to those benefits under the law, and if employers can go and intimidate people into not filing claims, that's a terrible bad thing. They're going to be able to sue you. They're going to be able to get punitive damages, and it's going to be very bad. So don't do that. We're going to stand behind people who get terminated under those circumstances. And so that's, I guess, the extent of where the interplay is. This has to do with the employment relationship as opposed to the injury that happens on the job.
So with that, then you can basically indicate then that in reality, this bill doesn't extend any new issues within workers' comp. In all reality, it just deals with the wrongful termination, which already was an exception. Is that correct?
Yes. Again, I'm sorry, Chair, through you to Senator Settlemyer.
You can go direct.
I appreciate that, Chair. This doesn't do anything to workers' compensation benefits or the benefits of medical treatment, temporary total disability benefits for while you're off work, permanent partial disability for any permanent issues that you have, and vocational rehabilitation. I mean, I guess it kind of touches on vocational rehabilitation, but it doesn't really affect the benefits, because if you aren't able to go back to the job that you had and you don't have existing marketable skills, and the employer doesn't offer you employment, you haven't been able to find other work, then you're going to be entitled to vocational rehabilitation, retraining. But that really is a separate concept as well from what we're talking about with the lawsuit for the intentional retaliatory termination of the employment because of the workers' comp claim. If that answers
I appreciate that. I appreciate the clarification, and I appreciate the indulgence, Chair. Thank you.
Sure. And I believe we have a question from Majority Leader Canizaro.
Thank you, Chair. I was curious, as we're talking about this amendment, and the statute of limitations not tolling until the exhaustion of administrative remedies. For a wrongful termination claim, is there a requirement to have brought that to an administrative body, or is that just a choice in terms of litigation, whether you would pursue a case or an administrative remedy?
Thank you, Vice Chair. Again, JP Kemp for the record. The common law claims don't go through any administrative process per se, but again, there are often companion theories that would require administrative exhaustion to go through the state or federal government agency in order to have them investigated, look at it, determine whether or not there's probable cause, and go through their dispute resolution processes. In fact, the EEOC, they don't bring very many cases every year, but they can actually bring their own case in which the employee would join. If they decide to do that, they have jurisdiction and the power to do that. But in the case of the common law case, there's no administrative exhaustion needed for that. But if you're going to bring a case, you want to bring one case. I mean, and I've had cases like that. I have one going on right now that originates out of Reno that we had to bring the case at 2 years, even though the matter was still with the administrative agency. We had to go and file with court, or we were going to lose that claim. You wouldn't be able to pursue that claim, and it would be terrible if you got down the road and the court said, yeah, if you'd brought that common law claim, that one makes a lot of sense. This statutory one that you're coming after them now, that one doesn't fly. So you've got to, and especially as an attorney, you've got to be careful. You've got to make sure that you are pursuing all available theories for your client. And so that's really where this is aimed at, is this this tension between those two things.
Thank you.
All right, are there any other questions from members of the committee? I'm not seeing any hands or anything else from our presenters before we move to testimony.
I have a question.
Senator Orrin. Oh, is that Senator Harris chiming in?
It is, yes.
Go ahead.
Thank you so much. My question is about the time limit that you have to file after you get some disposition from, let's say, the Nevada Equal Rights Commission. Is there a time limit there, and would that time limit still exist so that, you couldn't necessarily go all the way to the 2 years, but once there's an adjudication, you have 90 days?
Yeah. Senator Harris, thank you. That's an excellent question. I'm glad you reminded me of this. JP Kemp for the record. So after the whole administrative process plays out, if there isn't a resolution that's reached in the administrative process, you are given notice that the agency has gone as far as it can, and it now is closing its file, and you have 90 days to bring your lawsuit under the statutory claim. So the 90 days, that 90-day period is the time period in which you need to bring your claim, and that's true for both the state and the federal claims. Again, you file with one agency and they file with the other one automatically, or it's deemed filed automatically with the other one. And so both federal and state anti-discrimination laws have that 90-day period after they finish. Yes.
And I want to be clear, this bill doesn't affect that 90-day requirement.
No, it would not affect that at all. That is all covered under in NRS Chapter 613 and the federal anti-discrimination statutes that all provide for that 90 days. This does not touch that at all. This is specifically talking about common law tort actions for wrongful termination.
Thank you.
All right. If there's nothing else from members or presenters, Senator Orenshaw, did you have something to contribute?
Yes, thank you, Chair Scheibel, and thank you, members of the committee. Just wanted to address the issue of the exhaustion of administrative remedies. I believe the language in the proposed amendment allowing for the tolling pending that exhaustion of administrative remedies will try to help those be successful and avoid litigation. I want to thank Senator Settlemyre suggested that idea of rather than a number of months or years in statute that we go with that. And I think it's a great idea. I think that would give those administrative remedies, state and federal, a chance to try to solve the problem rather than a lawsuit being filed.
Thank you. All right, I'm not seeing anybody else raising a hand or jumping in here, so we will move on to testimony in support of SB 107. We will budget 20 minutes for that testimony, and each caller will be limited to 2 minutes per caller. If BPS would go ahead and start taking testimony in support.
Thank you, Chair Scheibel. To testify in support on SB 107, please press *9 now to take your place in the queue. Once again, to testify in support on SB 107, please press *9 now to take your place in the queue. And Chair, at this time, there is no one to give support testimony on SB 107.
All right, then we will move to testimony in opposition of Senate Bill 107.
Thank you, Chair. To testify in opposition on SB 107, please press *9 now to take your place in the queue. Once again, to testify in opposition on SB 107, please press *9 now to take your place in the queue. Caller with the last 3 digits 496, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Chair and members of the committee. My name is Alexandria Dazlich, D-A-Z-L-I-C-H, and I'm the Director of Government Relations for the Nevada Restaurant Association. We are here today to testify in opposition to SB 107, which would be disastrous to the restaurant industry. The restaurant industry is made up of thousands of small business owners who have poured their heart, their soul, and often their life savings into their businesses. They hire employees who they entrust to keep their business and their dream alive. Requiring restaurants to take on additional employment liability insurance costs can be very expensive to defend against, take considerable time to respond to, and may result in costly damages. Additionally, this bill will likely increase the cost of business liability insurance at a time when restaurants are struggling to keep doors open and employees on payroll. Employees who feel they have been wrongfully terminated have a right to file a legal claim and tend to take action quickly. However, allowing employees 2 additional years to apply for wrongful termination, especially at a time when hundreds of thousands of Nevadans have lost their jobs due to the pandemic, will have a devastating impact on small businesses, including restaurants. I urge you to oppose SB 107 for the sake of the restaurant industry. Thank you.
Thank you, caller. Caller with the last 3 digits 500, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Yes, my name is Brett Sutton, B-R-E-T-T, Sutton, S-U-T-T-O-N, and I'm testifying on behalf of myself. I've been practicing employment law. I'm licensed in Nevada for over 30 years. I'm also a member of the NFIB Leadership Council, and on behalf of the over 1,800 NFIB members around the state, we are strongly opposed to this legislation. The Nevada Supreme Court, in the decision that was alluded to by Mr. Kemp, after a thorough analysis, determined that 2 years was the appropriate statute of limitations for this claim. The district court before that reached the same conclusion, and I'd also like to note that our neighbor, California, has a 2-year statute of limitations for the same claim. To extend this to 4 years would be unprecedented, would be beyond what other states do, and would be totally unnecessary. One of the things that we need to note is, as Mr. Kemp stated, many of these claims do not go through the administrative process. And so there's no, when he made the argument that, you notify about this claim, the employer would be when they file an EEOC claim. Not all of these are EEOC claims. This really is more for what are referred to as common law claims. And then when you consider the fact that not only did the Nevada Supreme Court say 2 years, other states like California said 2 years, but also the federal government, when establishing the EEOC procedure, felt that 300 days was more than enough. there's absolutely no reason for 4 years. I can tell you from defending employers what will happen. Many of them will be caught off guard. They won't be able to find co-employees as witnesses. They won't have documents that they need, and memories will have faded. So it's really unfair, and there's just no current problem with the current 2-year statute of limitations, as has been recognized for the Nevada Supreme Court. So for those reasons, we strongly oppose this bill.
Thank you, caller. If you've recently just joined the call, we are currently on opposition testimony for SB 107. If you'd like to give that opposition testimony, please press *9 now to take your place in the queue. Caller with the last 3 digits 477, please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Once again, caller with the last 3 digits 477, please press *6 to unmute yourself, then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Yes, this is Robert Ostrovsky, O-S-T-R-O-V-S-K-Y. I'm here representing the Nevada Resort Association. We're in opposition to the bill as originally written. I will point out that the Nevada Justice Association didn't reach out to me and provided me an amendment earlier this morning. We have not had an opportunity to fully review that with my client. And I had promised the association that we would do so and then meet with them to see if there's any way we could develop an amendment that we could all support. So I'm more than willing to do that, and it will do that, but do oppose the bill as written. We agree that the Supreme Court's decision on 2 years was a unanimous decision by the court and believe it was appropriate, but we're willing to look at their alternative offer. Just as an aside, I was a respondent in the Harris versus Hansen case, which would have been the Lewis versus MGM case, but they took them in alphabetical order. So I'm very familiar with this issue going back for a long ways, and appreciate the Justice Association reaching out, and we will meet with them and report back to the committee if we can reach some compromise. Thank you.
Thank you. Caller with the last 3 digits 298, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Chair Scheibel. For the record, my name is Gina Bonjovi, B-O-N-G-I-O-V-I, and I am the chair of the Board of Trustees for the Vegas Chamber. As a small business owner and local attorney that almost exclusively represents small businesses, I'm greatly concerned with the provisions associated with Senate Bill 107 and share those concerns that have been expressed previously. As an attorney who works with small businesses every day, I can assure you that we don't succeed unless our employees succeed. Therefore, employers take wrongful termination lawsuits very seriously. In fact, we as employers take the act of termination itself very seriously, as terminating an employee is often not an easy decision. Wrongful termination cases, frivolous or not, are very expensive for an employer to defend against, take considerable time to respond to, and may result in costly damages. And SB 107 will make that proposition even more expensive. For a small business, this change to state law would require employers to retain records for even longer periods of time, create additional administrative burdens, and most certainly increase the cost of employment practice liability insurance. As we are barely starting to see the light at the end of the tunnel with this pandemic, I submit to you that now is not the time to burden the job creators with additional costs that may make putting Nevadans back to work a cost-prohibitive proposition. On behalf of our business community, we are opposed to this bill as written, but we are discussing with Senator Orenshaw and the proponent on a possible amendment and will continue to do so. Thank you.
Thank you, caller. Caller with the last 3 digits 973. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Greetings, Chair Scheibel, members of the committee. My name is David Edelblut, E-D-E-L-B-L-U-T-E. I'm a commercial litigation and government affairs attorney at Snell & Wilmer's Las Vegas office. Additionally, I am a committee member on Nevada's advisory committee to the U.S. Commission on Civil Rights. Through Snell and Wilmer, I am also a member of Henderson Chamber of Commerce, an organization that assists more than 1,800 businesses throughout Southern Nevada. I am here representing the Chamber in its interest today. We are in opposition to SB 107 as written. As an attorney who represents a range of businesses, from small family-owned businesses to Fortune 500 companies, I want to express the challenges they may experience with SB 107. While I appreciate the need to clarify Nevada statute of limitation provisions, we believe that increasing the limitation period for wrongful termination and several other actions will negatively impact businesses at a time when they desperately need our support. Section 1 of SB 107, which seeks to enlarge the limitations period for wrongful termination claims in Nevada from 2 to 4 years, doubles employers' exposure to liability in terms of time. For some, this may be the primary motive to support this bill, but such an amendment would harm businesses and create conflicts with other Nevada and federal laws. For example, NRS 608.115 requires employers to maintain wage records for only 2 years. Similarly, the Federal Fair Labor Standards Act requires covered employers to maintain those same pay records for 2 years and all other employee files for 3 years. If Section 1 of SB 107 goes into effect, the likelihood of filed claims with no wage records or other employee records significantly increases, which defeats the purpose of providing a larger limitations period in the first place. Section 2 of SB 07, which enlarges the limitations period for several other claims, is also bad for Nevada businesses. Two such examples are Minimum Wage Act claims in Nevada, which currently have a 2-year statute of limitations per the Nevada Supreme Court, as well as breach of fiduciary duty claims, which currently have a 3-year limitation period. The reasons for not supporting an expansion of those limitation periods also parallel
That brings you to
those
2
for
minutes.
wrongful
If you could
termination.
wrap up, please. Thank you.
Thank you.
Caller with the last 3 digits 580. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Madam Chair, members of the committee, for the record, I'm Paul Enos, E-N-O-S. I'm the CEO of the Nevada Trucking Association. I will just echo the comments of the previous testifiers in opposition to this bill. We do think that this does create an additional burden on employers, and I will leave it at that. Thank you.
Caller with the last 3 digits 116. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Thank you, Chair and members of the committee. My name is Alexis Motorex, Alexis Motarex. I'm here representing the Nevada Chapter Associated General Contractors. And we too are here in opposition to SB 107 as written. We appreciate being included in the conversation, but have not yet had a chance to fully digest the proposed amendment. We look forward to working with all the stakeholders and hopefully reaching a compromise language. Thank you.
Thank you, caller. Caller with the last 3 digits 216. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Once again, caller with the last 3 digits 216. Please press *6 now to unmute yourself and slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Chair and committee members. This is Brian Reeder, B-R-I-A-N-R-E-E-D-E-R. I'm speaking on behalf of the Nevada Contractors Association. As major employers in Southern Nevada, both big and small businesses, NCA is opposed to extending the statute of limitations to 4 years. We are reviewing the amendment and we will work with the bill sponsor, but we are opposed to the bill as written. Thank you.
Thank you. Caller with the last 3 digits 700. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair, or good afternoon, Chair, and members of the committee. My name is Brian Wachter, B-R-Y-A-N-W-A-C-H-T-E-R, with the Retail Association of Nevada. And to keep this short, we would echo the comments of the Restaurant Association, the Resort Association, and the Vegas Chamber of Commerce in our opposition to the bill. We are currently looking at the amendment that we got this morning, and we hope to be able to work together, but we believe that we will be in opposition to both as this bill moves forward. Thank you for your consideration.
And Chair, at this time, there are no more callers to give opposition testimony.
All right, thank you so much. We will close testimony in opposition to SB 107, and we will open up testimony in the neutral position on SB 107.
Thank you, Chair. To testify in neutral on SB 107, please press *9 now to take your place in the queue. Once again, to testify in opposition, in neutral standing on SB 107, please press *9 now to take your place in the queue. Caller with the last 3 digits 120, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the committee. Stephen Cohen for the record, Stephen with a V, Cohen as in the Assemblywoman, but no known relation that we're familiar with. In addition to echoing previous concerns, I want to just raise a couple of quick new ones. The first is claims against government employers. The 11th Amendment immunity clause in NRS 41 makes it essentially near impossible to litigate those. In addition, the non-economic damage provision in that same general provision of statute makes kind of limits damages to salary only. And then just to address one of the concerns that was raised by the presenter, in the context of workers' comp, the words vocational rehab are a misnomer because, unfortunately, somebody back in the 70s had the wise idea to call a federal program vocational rehabilitation. So I learned that lesson the hard way several years ago when a bill on that issue was presented. I do know that the sponsor of this bill in his committee has a bill pending that addresses state personnel, and then also another committee member has a standalone bill. I stand ready, willing, and able to work with the stakeholders to try to marry all three in some fashion to find a compromise. And with that, Madam Chair, thank you, and I yield.
Thank you, caller. If you've recently joined the call, we are currently on neutral testimony on SB 107. To give neutral testimony, please press *9 now to take your place in the queue. And Chair, at this time, there are no more callers to give neutral testimony.
Okay, thank you so much. We will close the hearing on SB 107, and that takes us to the last item on our agenda, public comment. If you wish to make public comment, please listen to our fantastic staff at BPS for the prompts, and you will have 2 minutes each.
Thank you, Chair. If you are here for public comment on SB 107, please press *9 now to take your place in the queue. Once again, if you are here for public comment, please press *9 now to take your place in the queue. And Chair, the phone lines are open and working. However, there is no one in line to give public comment at this time.
Okay, thank you so much. Our next meeting will not be tomorrow. It will be on Monday. It will be at 1 p.m. as usual. We have one bill to hear that day. The agenda is already posted on Nellis, and I will look forward to seeing you then. We are now adjourned.